Hi, my name is Megan Truick with the Law Office of Bryan Fagan. I'm one of their estate planning attorney here. Many people, when they hear the words estate planning, they're like, what is that? I don't even have an estate. Why should I be planning anything? But I can tell you that estate planning is for the living. It's the one way that you can unequivocally let your loved ones know that you love them. Estate planning arranges for the transfer of your assets at the time of your death to the owners that you may have designated in your will, or if you didn't have a will, by intestacy. An estate consists of all the property that you had at death before it's distributed according to your will or according to Texas state law. Therefore, your estate may include your real property, your house, your vacation house, your investment property, your car, your bank accounts, your 401ks, your security, your jewelry, and even your dog. Typically, the process of estate planning involves extensive consultation with different advisors. However, really, estate planning is about sitting down, talking to an estate planning attorney who, yes, will do the legwork of working with your financial advisors and counselors to make sure that your entire estate plan is holistically inclusive, but it's all about you. The purpose of estate planning is it benefits both large and small estates. So an estate plan is not just for the rich, it's for anyone who has a pulse. It's creating a plan that will work for you while you're alive, that will help to forward your personal wishes with what will happen to your body, what will happen to your assets, how you will live. And it's also about how your property will be distributed when you pass away. Specifically, estate planning allows for a person to decide exactly how their assets will benefit their lives when they're alive, and to what extent those assets will be distributed when they're no longer here. It ensures that an estate will not be divided by taxes imposed because of the transfer of those properties. It involves the minimization of tax consequences and avoiding probate if possible. It also involves guardianship for minor children, choosing your health care preferences, even your funeral arrangements, even the donation of your organs. So let's talk about some estate planning tools. An estate plan is created to reach specific goals that you may have. It's specific and unique for each individual. The number of tools that are utilized in your estate plan will also vary on the degree of difficulty that your estate plan may require. So the estate plan will be unique as to you because of the people you may be in charge of or responsible for in your life. It may be more inclusive depending on your medical history, what plans need to be in place in order to take care of you while you're living. So an estate plan may have a will. This is the most common instrument that's in an estate plan. At a minimum, your estate plan should have a will. And this sets out who will inherit your property if you pass away. It will appoint a guardian for your minor children, or may set specific arrangements at your time of death. All wills, however, must pass through probate unless you have made it so that no property will need to be probated when you pass. As a result, the will's beneficiaries may not receive the entire share of your estate if you dispose of things before or in different means. In the absence of a will, though, you will have passed intestate and your assets will be distributed according to Texas intestacy law. Generally, under the intestacy system, assets are divided in particular order to provide for the survival of a spouse, and may, depending on whether you have a spouse or children, it will dictate who will inherit and how much they will inherit. A second way is through trusts. A trust it's an arrangement. It's an arrangement wherein assets are placed in it under the guardianship and supervision of a trustee. Usually, if you set up a trust, you're going to be setting up maybe a revocable trust. You're going to be the initial trustee. You're the trustor, the trustee, and the primary beneficiary. And this trust will have all the property that at the end you want distributed to your loved ones. But while you're alive, the trust assets are for your benefit. The next thing that you may incorporate in your estate plan are healthcare directives. Healthcare directives ensure that your medical wishes take precedent and will be respected when you're unable to make those decisions for yourself. So the healthcare directive may include a power of attorney for healthcare decisions. It's also known as a living will. It sets forth your decisions when it comes to end-of-life care. It may set forward decisions when you are incapacitated. Maybe you're going into a surgery, and therefore there are certain things that you want respected while you're unconscious. It may also set do not resuscitate clauses, or it may have clauses that you must be resuscitated. Then finally, you may include a financial power of attorney. The financial power of attorney, durable POA, or you may hear it being called the statutory POA, is where you, the principal, is appointing an agent for your financial affairs. This document may be limited in time, or it may be limited in scope, in that it's limited to a specific purpose. But some powers of attorney are springing powers of attorney, so it springs to life when you're incapacitated. Or some of them are evergreen and becomes effective now until you revoke them. So those are some of the tools that you can use in your estate plan. But as I always say, an estate plan is the way that you can tell your loved ones that you love them. Thank you. My name again, Megan Truick with the Law Office of Bryan Fagan. You can see more videos like this at www.bryanfagan.com.